I'm the director of the Center on Women, Gender, and Public Policy, and we are very pleased that you've joined us today, whether in person or on Zoom. This will be a really important discussion on the state of abortion rights in the United States after the Dobbs decision. I'd like to begin by thanking our staff members who have helped to organize today's event. Jane Swift, who you may have seen at the door, our communications manager at the center, and Jenna Hoagie at the back of the room, our research assistant. And Kenny is on audiovisual today. I want to begin our event by acknowledging that we live, learn, and work each day on traditional, ancestral, and contemporary land of Indigenous peoples. The University of Minnesota Twin Cities is located in Dakota land that was ceded in the treaties of 1837 and 1851. And this institution would not be here today if it were not for the vast land resources taken during European colonization. As many of you know, there are 11 tribal nations in 4 Dakota and 7 Ojibwe that share geography with Minnesota. And we do a land acknowledgement at the beginning of our events as one way to educate our campus and community about this land, our relationships with it, and our history. Of course, it's only one start to a decolonization process. So the center tries to work towards decolonization through multiple relationships with both Indigenous peoples and organizations. We also strive to provide an intersectional analysis in everything that we do. For example, today our panelists are going to be talking about how inequalities of race and class intersect with those of gender in the area of abortion policy. As I'm sure many of you know, in April of this year, there was an astonishing development, a leak of a Supreme Court decision that indicated that the court would likely overturn over 50 years of abortion rights in the United States. On June 24th, the court did just that when it released the decision in the Dobbs versus Jackson Women's Health Organization case. The Dobbs decision has returned the regulation of abortion policy to the states, meaning we now have a patchwork of laws across the United States with some restricting abortions, others that continue to be in litigation processes over exactly what the law will be, and some like the state of Minnesota, where the right to abortion remains protected. So Minnesota now is in many ways an island in the upper Midwest of abortion rights. We have severe restrictions in place in South Dakota, some significant restrictions in North Dakota and Wisconsin, and in Iowa, while there's still quite a bit of debate over what law will be there, it's more restrictive than we have here today. So to talk about the implications of the Dobbs decision for abortion access across the United States in Minnesota and the history of how we got there, I have 3 esteemed panelists. I'm pleased to welcome Shayla Walker. Ms. Walker is Executive Director of Our Justice. Our Justice is a Twin Cities-based nonprofit organization that works to ensure that all people and communities have the power and resources to make sexual and reproductive health decisions with self-determination. Ms. Walker has dedicated her career to reproductive justice. She began as a phone counselor for Whole Women's Health, an independent abortion clinic, before she co-founded the Trust Collective in 2017. This is a collective that uplifts women and femmes of color to be engaged in reproductive justice storytelling. In 2019, she transitioned to the Vision Realization Advisor for Our Justice, and in January of 22, beginning of this year, became its executive director. We have next to Shayla, Christy Boraas. Dr. Boraas is an assistant professor in the Department of Obstetrics and Gynecology and Women's Health at the University of Minnesota. She received her master's degree in epidemiology from the University of Minnesota School of Public Health and her medical degree with honors from the University of Minnesota Medical School. In addition to being a Minnesota Monthly Top Doctor, Dr. Boraas is a family planning educator, training the next generation of reproductive health care providers. And then over Zoom behind us, we have Jill Hasday. Professor Hasday is Distinguished McKnight University Professor and Centennial Professor in Law at the University of Minnesota Law School. Professor Hasday teaches and writes about anti-discrimination law, constitutional law, family law, and legal history. Her most recent book, Intimate Lies and the Law, won the Scribes Award for the best work of legal scholarship published during the previous year, and the Forward Indies Book of the Year Award for family relationships. In the days since the Dobbs decision, Professor Hasday has been a key source for media as an expert to understand the legal implications of the Dobbs case. So before we begin our conversation, for those that are attending via Zoom, if you would please use the Q&A function. I will be monitoring that up here at the table and weave your questions into our conversation. And for those that are present, as you walked in, or if you didn't get it as you walked in, raise your hand. Jenna will hand you a note card and a pencil if you need. You can write your questions and she'll be handing them to me, and I'll also weave those into our conversation. All right, I'm going to take a seat and we'll start our conversation. I'm going to start with Professor Hasday. If you could please start us off with giving us some context for the June decision of Dobbs versus Jackson Women's Health. What were the reproductive rights guarantees that we had in the United States prior to this decision, and how has the Dobbs decision changed our legal context today?
Okay, thanks so much for having me. I
don't hear you.
I'm talking.
Try again.
Hello?
Okay.
Okay. Thanks so much for having me. I'm delighted to be here. I thought I would just start by giving an overview of the Supreme Court's 3 most important cases on abortion rights, just to get us all contextualized and oriented. The common law that governed the United States in its first decades after the founding didn't regulate abortion before quickening, which is the moment when the pregnant woman can first detect fetal movement, which can happen as late as 25 weeks into the pregnancy. There wasn't a wave of criminal prohibitions on abortion in the United States until the second half of the 19th century. This anti-abortion movement is led by male obstetricians, the American Medical Association. They have a variety of motivations, including they talk about fetal life, but they're also concerned that native-born white Protestant women are having too few children, they think, because they're having too many abortions. And they want to take over the field of childbirth from midwives, in part by tagging midwives with the slur of being abortionists. Over the late 19th and early 20th centuries, this AMA campaign is extraordinarily successful, and states pass a wave of abortion prohibitions. The Supreme Court first places constitutional limits on a legislature's ability to prohibit abortion in 1973 in Roe v. Wade. Just a few points of interest about the court's opinion in Roe. First, the court doesn't, in Roe, talk about abortion as a question of sex equality or sex discrimination. In some ways, that's unsurprising. When Roe was decided in 1973, the court is just beginning to get its sex discrimination jurisprudence off the ground. It's had very few cases and really hasn't had cause to think about, well, it has cause to think about sex equality, but it hasn't seized that momentum as of 1973. Instead of thinking about abortion in sex equality terms, Roe builds on a series of cases the court had previously decided, recognizing a constitutional right to privacy as part of the liberty protected in the 14th Amendment's Due Process Clause. For example, the court had held before Roe that the Due Process Clause's protection of liberty prevented states from banning people from accessing birth control. So Roe is framed as a continuation of this series of cases. Basic theory in Roe is that there's a constitutional right. This constitutional right to privacy places limits on a legislature's ability to regulate abortion. What does that mean more specifically? Roe creates a trimester framework for pregnancy, basically following the trimester division that doctors often use when talking about pregnancy. In the first trimester of pregnancy, Roe says states can't prohibit women from accessing abortion. In the second trimester, states can regulate abortion in the interest of maternal health and life. And in the third trimester of pregnancy, states can prohibit abortion as long as they make exceptions for a woman's life or health. The court argued that giving states the ability to prohibit abortion at the third trimester made sense because right around the start of the third trimester, as of 1973, was the moment when the fetus became viable, meaning that it was medically possible for a fetus born at that stage of gestation to survive outside the womb. Not that it was likely, but it was medically possible. When I first read Roe, two things stood out to me. First, the Roe court says almost nothing about women or about why a woman might want an abortion. In fact, most of the Roe decision is phrased as if this right to privacy is actually a doctor's right, and as if the problem with abortion regulation is the state is interfering with a doctor's exercise of his medical judgment. The second thing that's striking about Roe is a 7-2 decision, and it's clear that none of the justices in the majority or the dissent anticipated that Roe was going to become so famous and controversial. One of the few Supreme Court cases where many, many people know the name. I mean, it's even the answer in the New York Times crossword puzzle, which is very unusual for a Supreme Court case. In any event, Roe does become famous. And the popular academic theory for many years after Roe was that Roe itself created the anti-abortion movement. And maybe if the court had moved more slowly, the anti-abortion movement would not have coalesced. More recent historical work, however, shows, I think convincingly, that the anti-abortion movement really gets off the ground in the late 1960s as states, for instance, New York, begin to liberalize abortion laws. There wasn't an anti-abortion movement before because there's nothing for them to protest. Abortion is prohibited. So I think the more recent historical work shows that what gets the anti-abortion movement off the ground is the liberalization of abortion laws. And what keeps abortion at the forefront is that opposition to abortion becomes a central political issue, uniting two groups that previously had not voted together, evangelical Christians and Catholics. And that makes abortion an extremely salient political issue such that it's always debated. In any event, by the time the court decides the next big case in abortion, Planned Parenthood versus Casey in 1992, abortion had long been a central issue in American politics. Many people thought the court was poised to overturn Roe in this Casey case. Why? 5 justices on the court had been appointed by a president who explicitly said he wanted justice to overturn Roe. Ronald Reagan was very explicit about that. But in fact, the court does not overturn Roe in this Casey case. Instead, Justices O'Connor, Kennedy, and Souter, generally conservative justices, write a long plurality opinion that stresses the importance of respecting precedent, of respecting what the court's done before, and not succumbing to political pressure. The court's 1992 decision in Casey preserves constitutional limits on abortion regulation, but modifies the framework Roe had established. Casey's framework then remains in place for 30 years between 1992 and 2022. The basic idea of Casey is that after viability, states can prohibit abortion just like in Roe. Before viability, states can regulate abortion as long as their regulation doesn't impose an undue burden on women's access to abortion. Then there's a series of cases, where the argument is, does this particular restriction constitute an undue burden or not? And the court goes back and forth depending on the restriction. For instance, in Casey itself, the court holds that requiring married women to inform their husbands before they get an abortion is an undue burden, but says having a 24-hour waiting period is not an undue burden, even though for many women who are poor or highly regulated by abusive men, et cetera, having to do 2 doctor's visits is actually quite burdensome. Okay, so there's significant litigation about what constitutes an undue burden, but one thing that's clear in the 30 years after Casey and really the 49 years after Roe is that abortion before viability cannot be prohibited. That states cannot prohibit abortion before viability. They can regulate it, but they can't prohibit it. Okay, that brings us to the case the court just decided this summer, Dobbs v. Jackson Women's Health Organization. The bottom line of Dobbs is Dobbs held that the federal Constitution places no limits on legislative power to prohibit abortion. This means that Congress can absolutely prohibit abortion if it wants to and it has the votes. It also means that a state legislature can prohibit abortion if it wants to and has the votes, unless there's a state constitutional provision that imposes an obstacle. For example, in Minnesota, the Minnesota Supreme Court has interpreted our state constitution to include a constitutional right to privacy that protects abortion access. And the US Supreme Court decision in Dobbs has nothing to do with the meaning of the state constitution. It's just an interpretation of the federal constitution. Okay. So Dobbs holds the federal constitution places no limits on legislative authority to prohibit abortion. What's the court's basic argument? The basic move the court makes in Dobbs is the court says, when you think about what this word liberty in the due process clause of the 14th Amendment means, you need to go back in time to 1868, the moment when the 14th Amendment was ratified. And you need to ask yourself, the men in Congress who wrote and passed the 14th Amendment and the men in state legislatures who ratified the 14th Amendment, would they have thought they were placing constitutional constraints on abortion regulation? Well, no, they didn't think that. So the court says that 1868 understanding controls. If the men behind the 14th Amendment in 1868 didn't think they were placing restraints on abortion restriction, then the 14th Amendment does not place restraints on abortion restriction. There are many counter arguments to the court's theory. Among other things, why should women's control over their own lives in modern day America be controlled by what male elites thought over a century ago? Women are absolute, no woman can vote in 1868, women are denied political power, etc. Dobbs court also makes some other arguments. So for instance, Dobbs says, it's impossible for the court to know how losing access to abortion will affect women's lives, so we just won't consider it. There's counter arguments there. There's extensive studies documenting that having access to abortion is overall associated with better life outcomes for women, more likely to finish school, less likely to be in poverty, other children more likely to be doing well, et cetera, et cetera. Dobbs also rejects the idea of relying on precedent, which remember the Casey court had really stressed in upholding Dobbs. Dobbs basically said, we don't have to rely on precedent because Roe was so egregiously wrong. We just disagree with it and we're not following it. Okay. I just want to briefly say some of the legal ramifications of the Dobbs decision. First, for the law governing abortion. After Dobbs, Congress has the power to prohibit abortion nationwide if it wants to and has the votes. After Dobbs, state legislatures can prohibit abortion in their states. If they want to, they have the votes. There's no state constitutional obstacle. One question currently being disputed is what counts as an abortion. So as I'm sure many of you have seen, there's been many news stories of women who are in the process of miscarrying, and the doctors are afraid to provide care because they're worried about being prosecuted later for performing an abortion. So there's ongoing disputes about what constitutes an abortion. Another question Dobbs leaves open is how are interstate conflicts over abortion to be managed? Suppose a woman lives in a state that defines abortion as murder. Then she goes to a pro-choice state like Minnesota, has an abortion and comes back. Can her home state prosecute her? Can they try to go after the doctor in Minnesota for that? All of these will be fought out in the years ahead. Dobbs also doesn't make clear whether the justices think of that case as a midpoint or an endpoint. Many members of the anti-abortion movement support what they call fetal personhood. The idea of fetal personhood is that a fetus should be considered a full legal person with the same rights as anyone walking around in the street. And the constitutional argument behind fetal personhood is actually the Constitution should be read such that states can't allow abortion even if they want, because that's violating the constitutional rights of the fetus. There are breadcrumbs in Justice Alito's majority opinion in Dobbs that he is sympathetic to the fetal personhood argument. And if the court were to adopt that, then abortion would be prohibited throughout the United States. I just want to say a brief word about implications for Dobbs beyond abortion. So the court's opinion in Dobbs repeatedly declares that the court has this is only about abortion. We're not saying anything more generally about 14th Amendment law. But the court's basic theory in Dobbs places all of 14th Amendment law in jeopardy, because if the central argument in Dobbs is that in thinking about what liberty the 14th Amendment protects, we have to go back in time and ask what those male office holders would have thought in 1868. Well, did those male office holders think that they were restricting a state's ability to limit, same-sex marriage? No, they didn't. Did they think they were placing limits on the ability of a state to prohibit access to birth control? No, they didn't. So it's not clear how far the court will go with this argument, but the tenor of the Dobbs argument places many other aspects of 14th Amendment law in jeopardy. Okay, thanks very much. This is my overview.
Thank you, Jill. If I could ask you and also other panelists if they have input on this, what can you tell us about the state of abortion rights across the country as we speak? So how much has changed in the legal landscape? How many states have restricted rights? How many more do you expect to be doing that? What's the range of changes that we're seeing? I know it's been in flux. What can we say at this moment?
So I just looked it up. When about half the states are expected to want to enact abortion bans, but we're in process. So at the moment, all or nearly all abortions are banned in about 13 states: Alabama, Arkansas, Idaho, Kentucky, Louisiana, Mississippi, Missouri, Oklahoma, South Dakota, Tennessee, Texas, West Virginia. Wisconsin has a ban from the 19th century that they never took off the books. Right now, the state Democratic governor and attorney general are saying they're not going to prosecute it, but that's currently being litigated. And right now, abortions are not being provided in Wisconsin. And then there are other states that have short time limits. For instance, Georgia bans abortion after 6 weeks of pregnancy. The clock starts counting on pregnancy the day of the first day of your period. So when you actually get pregnant, you're already 2 weeks pregnant, according to doctors. So most people wouldn't even know that they were pregnant at 6 weeks. So on the one hand, it's not an absolute ban, but it's almost an absolute ban. Arizona and Florida ban abortions after 15 weeks. So, I mean, there's ongoing bans and it's continuing. I was speaking to someone who said between April and June, Minnesota saw a larger jump in the number of women having abortions in the state than it's ever seen. And that's all driven by people coming from out of state.
And maybe that's a good moment to turn to Shayla. I mean, so Shayla, you're on the ground providing and working with providers across the state. Are you seeing that increase? And what's the impact of the restrictions in neighboring states on providers here in Minnesota? Are we seeing sufficient capacity to provide for people that are seeking abortions?
Yeah, so at the fund, once the leak came out, we were getting prepared. We knew that we were going to anticipate a whole bunch of people traveling to Minnesota because we thought we would be the only state in the upper Midwest who would be able to provide abortions. But, you know, Michigan is coming through and hopefully they will. And Iowa, they're still doing what they got to do. And North Dakota, what a surprise. But, you know, we were really like getting all our volunteers ready, making sure the hotels were ready and they knew like that we were going to be sending more people to them. And that just didn't happen. There are a lot of reasons why people are not able to travel to Minnesota for their abortion. I was at a retreat with other reproductive justice organizers, and one of the organizers is from Mississippi, and she was organizing in Jackson. And she's told me, you know, we had such a difficult time getting people from, you know, a couple counties away to get to Jackson. How do you think people are going to make it from Mississippi to Minnesota? Even right before I came here, I was just texting somebody, getting their lodging set up and their hotel set up coming from Wisconsin. And we do have a lot of people from Wisconsin, but we have some people from Texas, a couple people from Missouri, one person from Mississippi who was able to make it. And it's just not about, you know, getting somebody to pay for your hotel or your bus ticket or your plane ticket. It's about finding somebody to take care of your kids. It's also about making sure that your boss is not going to fire you for missing so many days of work. It's about lost wages. There are so many barriers that prevent people from traveling, which we also, you know, though we support people who are traveling here and we still have like the hotels and the money ready to pay for their abortions, we're also supporting people where they're at. if they need information of how to, have an abortion where they're at, wherever they're at, we're here to provide that. And so, yeah, that's what's been on the ground. Like Jill said, we've had such an influx of people coming to Minnesota. I think, what was it? A study just came out and it said like we had an increase of something like 55%, but that's just not really reflected in the fund. And so that means there is a large disparity of who gets to have abortions. Basically, we're back to like, rich folks get to have abortions, white folks get to have abortion, people who have IDs. So undocumented folks don't get to have abortions if they don't have their ID to travel. Trans folks, they don't get to have their abortions if they don't have their ID to travel. Yeah, that's what we're seeing.
So when you provide information for people where they're at, are you also providing information on medical abortion?
Yeah, so we're giving information like to websites like Plan C. Plan C has a list of providers who offer medication abortion either through telehealth or they just mail you the medication. And there are a lot of like groups who are working to just get people their medications wherever they're at, no matter where.
All right. I want to remind folks on Zoom and in the audience that if you have questions, please post them either on the Q&A or on your note card and raise your hand and Jenna will get the note card from you. I'm going to go to Christy Boraas now. We've seen news stories from other states of women that have had a miscarriage or another complication during pregnancy, and then healthcare providers who, when they are in restrictive states, not knowing what they can legally do or not do to help a woman who clearly is facing personal health risks, potential death as a result of a pregnancy complication. So what's your sense of how healthcare providers are managing these changes in other states? I know you've got contacts from other parts of the country. And what can we do to ensure that providers do the ethically right thing and protect the health of pregnant people, even in restrictive contexts?
Yeah. I will tell you as a doctor, it's never a good day when you have to call your lawyer, no offense, Professor Hasday, before you provide, healthcare that you've been trained many, many years to provide. So yeah, I do. Fortunately, I think maybe Shayla and company have been preparing for the Dobbs decision for, when they said they'd take up the Jackson Women's Health, the Supreme Court I'm talking about, we're planning to take up that or decided to add that to their roster. We, as a, movement, as people who believe pregnant people should have access to essential healthcare, started planning from that day. So we were trying to be ready for influx of travelers. We were trying to mobilize providers, as a doctor who provides abortion care is pretty open about that. I had so many colleagues, OBGYN colleagues that I'd known for years that were supportive, but maybe not, stepping into those spaces with those patients that reached out and said, how can I help? I gotta help. And I was like, okay, well, let's figure it out. Come on in. The more, the merrier. And so I think that, and I've been pleasantly surprised by some of the major health systems, at least in the metro area, about their response to try to start to combat a little bit what Professor Hasday mentioned. Also, in our sort of legacy as physicians, and the stigmatization and the othering of this healthcare. So I've been pleasantly surprised, at least here again in the upper Midwest, about providers stepping in and joining and signing up and doing shifts and showing up for people. So that, if there's a silver lining of Dobbs, I guess maybe that would be it. And I'm excited that, we can continue to grow that and keep that right protected here in Minnesota. I am here on election day sort of standing in solidarity with my colleagues across the country where that is not the case, where they are not hopeful whatsoever, where my residency classmate had to involve the legal team before they could take a patient to the OR who had an ectopic pregnancy, a pregnancy implanted in the tube, never viable, never going to result in an infant, and has disastrous consequences potentially for the pregnant person's health. Had to have multiple conversations with the health system legal team before she was allowed to take that patient to the operating room. That has never been a consideration of mine up until Dobbs. And again, thankfully in Minnesota, it's not something that I deal with on a daily basis. You maybe saw, I had a friend of a friend that took care of a patient in Texas where the patient with a desired pregnancy, the water broke early at 18 weeks. Professor Hasday mentioned viability. 18 weeks is never a fetus or developing baby that could survive outside the uterus, even with the crazy cool advances that we have in NICUs across the country. So when the water breaks early, right, the pregnant person's risk, inherent risk for ascending infection grows exponentially, and it grows with each day. Prior to Dobbs, the recommendation from all people who are practicing evidence-based medicine would be that the risk of continuing that pregnancy outweighs the benefit. And that's what we would offer here too. Now, if the pregnant person says, I just need to wait, my calculation of that risk is such that I want to continue the pregnancy and wait. Great. We will support you. We will see, we will be there with you and support you with whatever you need when you need it. That's not the case for my friend in Texas, right? Who had to turn that person away and offer nothing but expectant management, but waiting until 5 days later, that patient came back, floridly sepsis, whole body system infection, and had to be admitted to the ICU for 5 days. And thankfully survived with her uterus, right? The risk, right, if you have infection so significant in the uterus is that sometimes the only way to treat it is to take it out. And what that means then for somebody's future fertility and ability to have, the families that they want.
So you talked a little bit about providers stepping up, and my understanding is am I right about this, that only the University of Minnesota Health System has provided abortions up until this point, but there's been talk among other providers, systems of providing abortion. What's the status of those conversations of expanding provider access or providers?
Okay, so this is a long sordid story. And I'm not going to try not to get in trouble with what I say, but I think part of the problem and why we are where we are today is that major health systems all over the country and the leadership thereof are unwilling to stand up and recognize, again, with the sordid history we have of this in this country, of the AMA and people there within relegating this care to the shadows, right? And so that still happens today. Nobody wants to say the word abortion, and that's part of why we're here. I can only speak to the health system that I work in, but no health system in Minnesota can deny somebody emergency care that needs it.
Okay.
What I can
Like
say about
Dr.
that.
Boraas said, it's hard because people want to de-silo abortion from general health. Abortion is healthcare. It's essential healthcare. It's part of pregnancy care. And for so long, it's been in the shadows. And so I think, one thing that has made it really challenging too, which was resolved with, our case. So our justice, we are a plaintiff in the case Doe v. Minnesota, which had some significant wins this summer. And we joined that lawsuit because we wanted to defend Doe v. Gomez. We were a plaintiff in that as well. And we were able to get the 24-hour waiting period removed. We were able to get the physician-only law removed. So now advanced practice clinicians can also practice abortion in Minnesota. We were able to get the judicial bypass moved. So now minors are able to go ahead and get care without having to be seen by a judge. So there were so many restrictions, even though we are like, quote unquote oasis of care in Minnesota, there were restrictions that went against our state constitution, and that we had to go ahead and sue so they can be removed because bad laws get passed. But now with APCs, we're part of a coalition. Our justice is part of a coalition called Unrestrict Minnesota, which was made in part to educate Minnesotans about the restrictions, about the lawsuit. And now part of our education is educating advanced practice clinicians about the opportunities to get training for abortion care. So that wasn't an opportunity that people had prior to this summer. Yeah. And so it wasn't even before, it was not even the Dobbs leak. Now that I'm thinking about it, I'm like, we've been preparing for this for a long, long time. All the proactive work we've done by joining the lawsuit, it was in preparation for this moment because we knew that down the pipeline, restriction after restriction with all the trap laws that started 2011, 2012, it was inevitable. It was going to come down. And so we've been preparing for this for a very long time. We've been trying, our justice specifically has been trying to work with larger medical orgs like, Mayo Clinic for the longest time. I've been in abortion care since 2012, 2011. So for the longest time, we didn't have a connect at Mayo, but then all of a sudden Roe v. Wade fell, and then people at Mayo are like, oh yeah, we're going to do abortions. And so even if there are institution who does abortions, it's like, if you don't talk about it and you're not in community with the people who are doing the advocacy, then if I don't know, how is a person going to know? How is just any regular person going to know if the person who's an expert on abortion care doesn't know that they do this? And so I think, it's just really difficult to, tell folks like that, hey, all these different providers are offering abortion care when you don't have the backing and the support of the institution, when they're not out loud about abortion. And I think that's what we're asking people. We're asking institution to be out loud about abortion and to include it in the talks about your general health care, and not to de-silo it from the healthcare. At least that's what I'm asking.
So maybe staying on this theme of providers, Dr. Boraas, can you tell us what are the impacts you're seeing on OB preparation programs? This is a question from the audience.
Yeah. We, as a University of Minnesota OBGYN program, have our first virtual, they're all virtual now, resident interviews yesterday. We do a series of days in the fall. And our applications went up significantly this year. We always are well represented in the upper Midwest, but we had many more applicants from out of state. I think we will see this on the trickle down to fellowships. So after OBGYN residency, you can choose to subspecialize in high-risk pregnancy, where you're diagnosing people with fetal diagnoses and anencephaly where the majority of the brain doesn't form, other fetal anomalies. What kind of moral injury is that to continue to have to practice in some place where you tell people that and then just stop talking, where you just disclose that information and then have nothing to offer. So I think we will see it trickle down to fellowships. It crosses borders into all types of healthcare. People with cancer become pregnant, people with major, morbidities, health-wise, heart transplants, people with kidney, people that have medical comorbidities that maybe put them at significant risk to their own health to continue a pregnancy even outside the first trimester, that will not be able to access care. And those people are often also too sick to travel. So if you are internal review committee, I mean, how close does a pregnant person have to be to death to qualify as near death? 10%, 50%? I don't know. And I think a person can only practice in that environment for so long before, that comes and seeps into home life, relationships, et cetera. If you continually have to show up and not do the right thing.
I want to transition here to the theme of reproductive justice. I was interested, Shayla, about how our justice used to be called pro-choice resources, and then there was a name change in 2017 to reflect the commitment of the organization to reproductive justice, not just reproductive choice. And so that term is something that, at least from my understanding, was conceptualized by women that found the pro-choice narrative to be exclusionary, especially of histories in this country, especially of eugenics and controlling of whether or not women of color in particular could have children, so that expanding the ideas about reproductive justice to thinking about all kinds of ways in which individuals seek to reproduce or not reproduce. All right, so can you tell us how does our justice, especially in this highly focused moment on abortion, implement a reproductive justice approach?
Yeah. So our justice, we're implementing a reproductive justice approach by really focusing on that, even though this is like a moment of like, it's a very important moment. It's a very dynamic moment. We are slowing down and we're not moving at the pace of urgency. Like I said, we knew this was coming down the pipeline for a very long time. And so instead of being reactive, we were proactive. Back in 2019, we decided, yeah, we're going to be part of a lawsuit. And so it's just not, it's not just like about this moment about Dobbs. It is about moving in a way that honors the values of the reproductive justice framework. And so that means we're in communities, we're talking to people, not just about abortion access, but about bodily autonomy in general. When everything went down in 2020, we were out in the front lines, like at the same time that we were, pledging for people's abortions, we were over here helping folks get helping activists get connected to medics. We were helping people get connected to healers. We helped an organization called Cocoa Butter Futures open up a food pantry where they were not only just distributing food, but they were distributing diapers, and they're still going till this day. And so it's more than just, being present for when there's things going down with abortion access, which is always going to be at the forefront of our minds, but also just expanding to make sure that the community knows that we're there for their reproductive justice, like no matter what. If you need a diaper, if you need a Plan B, which we started a Plan B delivery program, if you need a connect to like sexual violence center, that we're here for that. And that we're just not going with like all the noise that's happening at one time. For example, there was like a huge rally that was being planned after the fall of Roe. And we had an opportunity to be like part of like, heading of the planning. And we decided, we'll take part of it, but that's not where we're going to spend our energy, is planning a rally. We're actually going to pivot and focus on what we've been working on, which was trying to get money from the city of Minneapolis approved. So we were trying to get $800,000 and we actually got $300,000 approved by the mayor. And so we wanted to make sure that in this time where everybody was like, oh my gosh, we're panicking, we have to like show up, we have to like, be loud and proud. And we're like, yeah, loud and proud, but we need to show up in a way that is really going to impact folks, and that's going to be long-term. So why don't we go ahead and like get this money moving for the city of Minneapolis, so that the people in Minneapolis and people who are traveling to Minneapolis will be able to benefit from this moment. Because at that rally, then we were able to get the signatures, and the signatures were able to like go ahead and convince the city to go ahead and invest in this initiative. So just using the moment and pivoting it from like, I feel like it was just like so much, I don't even know how to describe it. It was just like so much anxiety, like such a heightened state of mind that everybody was in. And we're like, okay, how do we like hunker down and like really focus and use all the attention and all the resources to build a foundation for something that will last.
All right. I'm going to pivot back to the legal side a little bit and bring Professor Hasday in. So you had mentioned the Minnesota Constitution and how that was not impacted by the Dobbs decision, but still the decision in Doe v. Gomez in 1995 was based upon privacy within the Minnesota Constitution. So given its reliance on privacy and not sex discrimination, for example, as you raised earlier in your opening remarks as being not part of the original Roe decision, is Minnesota's status as an island of abortion rights secure? Is there the possibility, or how easy would it be to overturn the Doe v. Gomez decision?
Okay, so how could abortion be restricted?
We don't have volume here. Hang on. Okay, let's try again. No. Oh, wait.
Can you hear me now?
Yes.
Okay. So how could abortion access be restricted in Minnesota? First, what could happen within Minnesota? So in 1995, the Minnesota Supreme Court, which is the ultimate interpreter of the Minnesota Constitution, and Doe v. Gomez said there's a right to privacy in the Minnesota Constitution that restrains the ability of legislatures to restrict abortion. After Doe v. Gomez, there really weren't follow-up cases until this case, which Shayla was just mentioning, Doe v. Minnesota, which is just decided by the District Court of Minnesota, that really elaborated on Gomez and said the key is not just having a formal right to abortion, but it's actually having a practical access to abortion. If you want to get an abortion, can you actually have it? And relying on that theory, the court struck down the wide array of abortion restrictions that the legislature had enacted, including, I think we were the only state you had to get parental notification from both parents, even if you really weren't in contact with one. There was a 24-hour waiting period, etc. Keith Ellickson said he is not appealing that ruling from the district court, so that stands. How could it be in jeopardy? Well, the Minnesota governor appoints new justices to the Supreme Court. There's fairly regular turnover because there's mandatory retirement age 70. Then they run for election every 6 years, but that tends not to be a contested election. So if we had an anti-abortion governor, he could appoint anti-abortion justices who might revise their interpretation of the Minnesota Constitution. Minnesota legislators could propose an amendment to the Minnesota Constitution, either explicitly including a right to abortion or allowing the legislature to prohibit abortion. To amend the Minnesota Constitution, you need a majority of each house of the Minnesota legislature, and then it goes to the voters. You need a majority of the voters voting in the election. So that's how it could change internally in Minnesota, basically new justices on the Minnesota Supreme Court or a Minnesota constitutional amendment. Abortion could also be out of Minnesota's hands because of actions by the federal government. So if Congress decides to prohibit abortion nationwide, or even to put a short time limit on it. There's nothing that the Minnesota legislature or the Minnesota Supreme Court can do about that. Also, if the US Supreme Court adopts this fetal personhood theory and says actually fetuses have constitutional rights, abortion can't be allowed in the United States, there's nothing Minnesota can do. So I would say, I don't want to speculate on the likelihood of any of those things, but those are all possible. I guess one thing I will say is, I think the Supreme Court itself hasn't fully decided how far it's going to take Dobbs. Is it going to embrace, for instance, the fetal personhood theory? Is it going to undo all of 14th Amendment law? And one of the things that determines it is exactly how much pushback it gets from Dobbs itself.
All right. We've got one question from the audience here saying that in states like Minnesota, where abortion is legal, what could the role of sheriffs be to extradite patients? Should states enact laws that
that's a good
criminalize
question.
people for traveling out of state for abortion care?
So Keith Ellison has said,
that could go to any one of you.
I can answer that one. Keith Ellison has said that he is not participating in extradition attempts. So he is not helping an anti-abortion state get a doctor or get a patient. It's possible if there was an anti-abortion attorney general, they would participate in extradition. So that's one reason why it matters who's a state attorney general. I will say that even regardless of the attorney general's cooperation, it may be difficult for Minnesota to resist efforts by other states. So for instance, in general, one state has to honor the judgments of another state. Usually this isn't controversial because it's a way so that people can't escape their contractual obligations by just fleeing the state they're in. But suppose Texas says as a civil judgment against a doctor in Minnesota for providing an abortion to a Texas woman, will that be enforced if the doctor remains in Minnesota? All that, no one knows the answer to those questions. That'll all be fought out.
I want to stay on this privacy theme a little longer. So we see abortion rights based upon privacy in both Minnesota and previously in federal law based on the U.S. Constitution. Other countries in which abortion is legal, and we've had some folks write about this in our blog, the Gender Policy Report, have written about countries where it's because of a right to health or because a human right. And so what's the future in terms of those that want to see the reestablishment of a legal right to abortion? Is it through to continue to go through privacy law? Are there other legal avenues? Are there other social movement avenues in the sense of how we frame this right and why it's important? And that's a question for all three of you, whoever would like to start.
As a non-attorney on this panel, can I say the Equal Rights Amendment?
Yes, and what's interesting actually is
wait, I have to get volume for Jill.
Oh, sorry.
Hang on, Jill. We have to, I guess we're putting your volume up and down.
Sorry.
Okay.
I'm writing a chapter in the book I'm working on anti-feminists, and one of their main arguments now against the Equal Rights Amendment is that it would enshrine abortion rights, which I think is interesting. Yeah, privacy was never the greatest framework. I think the best example of this is the Hyde Amendment was a federal law that said even when there was constitutional protection for abortion, the federal government didn't have to provide abortions to indigent women who were otherwise getting their health care through Medicaid. And basically, the court really relied on this privacy theory. Privacy is about being left alone. It's not actually about have access to it. So I think that's a real limitation of the privacy theory. Being left alone works if you have all the resources to make it happen. You just need the state to stay away. But a lot of people don't need to be left alone. They actually need to be helped to be able to do what they want. I personally think a equality framework is much more rich for me. One of the things that's very interesting about the Dobbs decision itself, which I didn't say before, is the court rejects in 2 sentences the idea that abortion and sex equality could be linked, and says virtually nothing about the relationship between abortion and women's lives. I think, not to speculate, but I think one reason is because it doesn't really want to engage with the way that getting rid of abortion rights really jeopardizes women, including women that the majority of the Supreme Court might be quite sympathetic to. right? Women who are miscarrying from desired pregnancies. I don't think that that was the image that many Americans had, that this would be, women with ectopic pregnancies dying because no one will help them. It's hard to see, who's the median voter supporting that.
Thanks. I know that you're going to have to leave in a few minutes. Jill, do you want to stay on with us or?
If you're still talking, I stay on. When you move to
Okay.
social,
Okay, sounds good. I wanted to see if Shayla, did you have anything you want to say about the right to privacy and what are some of is that the appropriate framing going forward, especially from a more social movement aspect and organizing aspect?
No, because look at where it's gotten us. Like, we tried the right to privacy and clearly that didn't work. I'm not a lawyer, and like, to be very transparent, like, the Constitution deemed my ancestors like not people. So I wouldn't even know where to start with that question. In terms of like, how would we use this system to support and like protect people? Yeah, if we're not coming from like a human rights point of view, I don't know what that would look like, right? Reproductive justice says like we have the right to have children, not have children, and to parent the children we have in safe and healthy environments. And I don't know if that is something that the United States Constitution would ever like consider supporting, to be really frank.
And I think there's just no better decision maker about healthcare decisions regarding pregnancy than the pregnant person. Full stop.
So I have another legal oriented question here from the audience. So this person says, I keep thinking about how Ruth Bader Ginsburg would frame this now in the context of sex discrimination. Is there anything comparable in men's health that we could use to show how unevenly this country applies control? How we don't exercise control over men's bodies, for example, forced vasectomies?
I don't know if you remember, but
Or getting your volume up.
okay. I don't know if you remember, but someone actually asked Brett Kavanaugh who was one of the justices in the Dobbs majority overturning Roe, if there was an equivalent example where the state stops men from making healthcare decisions, and he did not have one. It's very hard to think of one. And I don't think there's a way in which abortion is an outlier, but there's also a way in which it isn't. So if you think of, for instance, like the military was extremely quick to provide like Viagra benefits in its healthcare, there's certain interests that society tends to accommodate and there's others it doesn't. Another way to see this is when you survey people on abortion rights, the numbers really vary based on how you phrase the question. So there's widespread support for rape and incest exceptions. In some surveys, over 90%. That's one reason it's so remarkable, the states that don't have rape or incest exceptions. But there tends to be much less vocalized support for having an abortion so you can pursue your education or your career. And that's not a judgment about fetal life. That's a judgment about women and what they should do with their lives. And I don't think you can understand the abortion debate apart from a debate about women's roles and what women should prioritize.
So I've got two more questions and then I'll close us out. One from the audience here. In September, the Minnesota AFL-CIO unanimously passed a resolution in support of abortion, the right to choose, and the new union of Planned Parenthood North Central State Workers. How can employers, labor unions, and organizations protect workers' right and access to abortion care here in the Midwest and across the U.S.? So this is an avenue for moving forward, right? Having it something that's a platform of workers. So Jill, you're gonna answer.
I have one idea. I don't know if you can hear me or not. Yeah, okay, I can hear my closed captioning. Just to go back to the reproductive framework. When you think about giving people autonomy, one thing that gives people autonomy is protection against pregnancy discrimination, which is very widespread. And that is something completely in employers' control. So don't discriminate against people for being pregnant. Don't discriminate against people for being mothers. And of course, don't discriminate if for seeking abortion care. I agree that just thinking about abortion in isolation really doesn't capture it. It's really about giving people control over their own lives, and then the ability to raise the children they want.
I would say too, from an employer standpoint, mandating, I don't think any pregnant person should have to tell their employer anything about their pregnancy. Again, full stop. And unions, I think, have a strong potential to advocate for what type of healthcare is offered in through that employment, right? If you are accessing employer-based healthcare coverage, the employer has a lot of bargaining in what those options look like, right? And if they don't include abortion, maybe they should. And maybe that's where, the power of the numbers of your organization and your bargaining power can come into play, that we will not offer employees an option that doesn't include abortion care.
It's hard for me to answer because I'm like, your insurance shouldn't be tied to your employment. Like, why is your insurance tied to where you work at? That's just so weird.
Or where you don't work at.
Or where you don't work at. Yeah.
Another argument for universal healthcare on the table, sounds like to me. I'd like to end us with this question. So it's election day. Hopefully most of you have voted at this point, or you've got a plan coming up. We've heard how important the elections of some of the offices here in Minnesota may be for the continuation of abortion rights in this state. So for those that want to see abortion rights restored and reproductive justice realized throughout the U.S. beyond voting, how do you recommend that people become involved if they want to get involved?
I would say donate to your local abortion fund, or look into the National Network of Abortion Funds or Apiary Collective. Apiary Collective is a group that does logistical support across the nation, and the National Network of Abortion Funds, that is just an organization that it doesn't house all the abortion funds under the in the nation, but it is like a network where we are able to like share and exchange information as funds. And so just supporting the national network so that we can get updated, software, so we can protect our data, we can protect the security and the safety of the people that we serve. I think a lot of people, they don't understand, like, a lot of these groups are volunteer groups. Our Justice is one of the few organizations who have paid staff, and we have 3 staff members, and myself included. But the rest of them are just volunteer networks, and they're throwing down their own money to get people to and from their appointments, to donate to, or to make pledges, and to like just organize. And so supporting like on the ground organizations through just talking about them and just educating people about them, because people don't know a lot about abortion funds. Well, at least they didn't know before Dobbs. And then just donating to them, because donations is what we need. This is what we do. We give people money, so we need money to give the money. So donating.
I have a t-shirt that says, say the word abortion. And I think that's what I would say. We hear about, or our society glorifies in lots of, I mean, I deliver babies and lots of times in a really fun and glorious and lovely way, but we don't hear about the range of pregnancy outcomes that can occur and what that might mean for the person who's pregnant and their loved ones. And I think talking about, just talking about those with your family, like it's not super fun, like Thanksgiving table conversation. But when you dive into those conversations, right, you'll say, oh, I had a miscarriage. Oh,
Yeah.
I had an abortion when I was 18, or, you'll be surprised. And if nobody is talking about it, then people can't understand the ramifications of what we don't understand.
Mm-hmm.
And so I'd say start there.
Everybody loves someone who's had an abortion.
1 in 4 people.
Jill Hasday?
I would also say,
Oh, we got to put your volume up.
I agree with all of those things. I would say first vote, but I would say second, this is really a time for energy. What is going to be the ultimate implications of Dobbs are still being worked out. And if you're thinking of law school, I know a lot of people are very demoralized about the legal system, and I completely understand that. But the need for lawyers has gone up rather than down. There's going to be one thing about putting it to the states is there's going to be a lot of hard-fought legal battles that will end up having really practical consequences for people's lives.
All
Yeah.
right. Wait, did you
Go to
wanna
law
add something?
school and be my lawyer.
Yes, we need lawyers.
Public policy is not bad either. All right. And so with that, I'm going to say a huge round of applause to our panelists. Thank you to our audience for attending both in person and online. For those that are here in person, please stick around if you have a few minutes to have some coffee, tea, and snack. Thank you.
I know so many beverages. I gotta stay hydrated.